short but important question involved in these matters is whether the assent given by the President under Article 254(2) of the Constitution of India with regard to the repugnancy of the state legislation and the earlier law made by Parliament or the existing law could only be qua the assent sought by the state with regard to repugnancy of the laws mentioned in the submission made to the President for consideration before the grant of assent, or would it prevail qua other laws for which no assent was sought? Your Lordships would mark 254(2) is just, my Lord, the cause for exercise of 200. 254(2) says that if there is repugnancy between central and state law, then President would go under 200 and seek assent. The contention is, once the President grants the assent to the state legislation, the state law would prevail on the said subject, and such assent would be deemed to be an assent qua all earlier enactments made by the Parliament on the subject. The contention is negative for the reason recorded hereinafter. It is held that consideration by the President and his assent under Article 254(2) is limited to the proposal made by the state government. The state legislation would prevail only qua the laws for which repugnancy was pointed out and the assent of the President was sought for. Proposal by the state is a sine qua non for consideration and assent. Just to broadly point out, suppose the Honorable Governor feels that it is repugnant to two central acts and forwards, my Lord, for the assent of his Honorable Governor. But it is found that it was repugnant to 5 central laws. What would be the effect of the assent? And one of the main questions which arose was, can the assent ever be justiciable? I'm sorry, my Lord. Yes. My Lord, kindly now come to para 23. Para 23, the 6673. The learned senior counsel, Mr. Nariman, next submitted that the assent given by the President is not justiciable and placed reliance upon the decision of this court in Bharat Srivastram Sangh versus State of Gujarat, wherein this court observed thus: it cannot be said that the assent which was given by the President was conditional. The records relating to the above proceedings were also made available to the court. On going through the material placed before us, we are satisfied that the President had given assent to the act, and it is not correct to say that it was a qualified assent. The act, which was duly published in the official gazette, contains the recitals that the said act had received the assent of the President on so and so. Moreover, questions relating to the fact whether assent is given by the Governor or the President cannot be agitated also in this manner. In haste versus so and so, this court has observed we have no hesitation in holding that the assent of the President is not justiciable, and we cannot spell out any infirmity arising out of his decision to give such assent. My Lord, now your Lordships may kindly see, haste is again quoted, which I have read, I'll skip, my Lord, para 25. In our view, for finding out whether the assent was given qua the repugnancy between the state legislation and the earlier law made by Parliament, there is no question of deciding validity of such assent, nor the assent is subjected to any judicial review. That is to say, merely looking at the record for which assent was sought would not mean that the court is deciding whether assent is rightly, wrongly, or erroneously granted. The consideration by the court is limited to the extent that whether the state has sought assent qua particular earlier law or laws made by the Parliament prevailing in the state, or it has sought general consent. In such a case, the court is not required to decide the validity of the assent granted by the President. In the present case, the assent was given after considering the extent and nature of repugnancy between Bombay Rent Act and Transfer of Property Act as well. President so and so. Therefore, it would be totally unjustified to hold that once the assent is granted by the President, the state law would prevail. No? That is on the facts of the case. Now, my lord, I would respectfully substantiate this submission, my lord, on the ground of doctrine of separation of powers and, my lord, on the ground that non-justiciability of constitutionally coordinate organs is a part of separation of powers, my lord. And that is how, my lord, your lordships have construed. My lord, if your lordships can now consider coming to another angle from which, my lord, this can be seen. My lord, suppose assent is granted as per the aid and advice of the Council of Ministers. There is no dispute between the governor, the view of the governor and the view of the council. My lord, Article 163(3) specifically prohibits the court from examining what advice was granted. Consequently, as a consequence, my lord, it would also prohibit the Honorable Court from inquiring why and for what reason the assent was granted. This is one facet. Second, my lord, suppose assent is granted, justiciability, my lord, according to two judgments, it's not justiciable. Suppose the Honorable Governor chooses the route provided under the proviso that first I would send it back with a message, then even that would be subject matter of judicial review. After the proviso, my lord, operates and the bill is again presented to him with or without modifications, he may choose to refer it to the President. That again can be subject matter of judicial challenge. Therefore, my lord, my respectful submission, my lord, thereafter it would go to the President. The President also may again choose to send it back to the legislature under Article 201. That again can be a subject matter of challenge. Thereafter, my lord, the President may grant assent. That would also be a subject matter of challenge. My lord, the question is, in the scheme of things, my lord, when the Governor and the President are exercising legislative powers, being part of the Assembly and the Parliament respectively, my lord, is such multi-pronged attacks by way of a judicial review is contemplated. And my lord, in my respectful submission, the answer is no. If your lordships can only come to, my lord, page.
So, see, if the assent is granted
Yes,
by the governor or the president, no question, because it becomes a law. If it chooses to go through the proviso, whatever, it is taken to the logical end. So either he grants assent or not.
Can I just interrupt here with your lordship's permission?
But if the governor withholds it for unlimited period.
No, Lord, again, I'm not repeating it. Withhold is permanent withhold. It's an act by.
Permanent withhold, because
Yes.
from your chart, permanent withhold and temporary withhold.
Yes, yes, there can be, but that's a possibility.
Yes.
But, my lord, please see, my lord, the title of Article 200. It said assent of the governor. Assent is one. It has three facets: grant, withholding, reserving. So what, in my respectful submission, is not justiciable is exercise of powers under Article 200 and 201.
So according to you, 200 is totally beyond the scope of judicial review and justiciability.
Well, Lord, it is not justiciable. Not similar, again, contrary to the.
Justiciable in the sense, it's a decision and decision-making process. The decision is not justiciable. That why the president or the governor has assented to. That may not, the court may not examine it. The court can examine this aspect if there is a question of repugnancy or question of constitutionality of law will come. There the court will not examine the assent, the court will examine the very competence of the legislation.
And the act itself.
Act itself. Exactly. Here the question is of decision-making process, not the decision ultimately taken. So in the decision-making process, the court, as the rightly observed by the question bench, will call for the file, for what purpose the state had sought assent, to what extent, what were the laws. That process can be examined by the court. So it will fall within the ambit of judicial review. What is not justiciable is decision, assent, but process is.
My difficulty is my difficulty means the difficulty which I foresee is multi-level challenges. For example, if grant of assent per se can be challenged, the option of the governor to send it, return it to the house also is a decision under 200. First option. That also can be challenged, that he could not have, because there is no repugnancy, or their governor can also send it without repugnancy.
That's also
It's
decision.
already-
Decision, it will not be challenged.
It cannot be challenged. That's my submission. Lord, suppose he chooses that I would I would refer it to the president for presidential assent. That is also a decision under 200. My lord, and all this, my lord, are isolated and independent powers, but can be exercised consequentially also. For example, Lord, a governor may say that right now I am not granting assent, I am returning the bill with amendment. The amendment may not be based upon repugnancy argument. He may just, the proviso say even desirability. The governor says that it is desirable that instead of, say, age is the subject matter. I am just giving a hypothetical example. Age is the subject matter. Then instead of 21 years of age, you are fixing, make it 25. It goes back. That is a decision, again, my lord, subject to challenge if your lordship holds that it is justiciable. Thereafter, my lord, the parliament, the assembly would return it with or without, my lord, the acceptance of his recommendation. Then also his option is available. If it is repugnant or otherwise required to be referred to the President of India, he can again refer it to the President of India. At that stage also, my lord, if it is justiciable, it can be put to challenge. Same thing would happen when the bill is received by the President of India, referred by. The President may again send it back to the House that I am suggesting something else, or according to me, the governor has not found it, but I am finding it, there is something repugnant, and I am returning it back. There is no prohibition. The President can do that. That is a decision under Article 201. Lord, again, that would be justiciable. Therefore, my lord, my respectful submission is that this being plenary legislative powers exercised by coordinate constitutional functionaries are, my lord, outside the pale of justiciability. My lord, because if it is a grant of assent, my lord, the question of, my lord, challenge will not arise, because then the act will be under challenge. Act can be under challenge, and there is no difficulty about it. There cannot be any argument. Lord, kindly have a look at page 254. What first 253. Lord, I have read it, but just for ready reference, Council of Ministers to aid and advise the governor. 253. Lord, it is always, my lord, safe to save the jurisdiction of the court, and I am conscious of that fact. But, Lord, as it would, my lord, I would try to make it clear subsequently, Lord, this theory, separation of powers amongst coordinate constitutional functionaries, is a theory accepted in our constitutional principles. Therefore, in case of 200 and 201, Lord, it is, according to me, my lord, non-justiciable. Lord, please see 163, Council of Ministers to aid and advise the governor. But please see 3, the question whether any, and if so what, advice was tendered by ministers to the governor shall not be inquired into in any court. Kindly pause here for a minute, my lord, and let me give, my lord, one hypothetical example. My lord, the outgoing government has hurriedly passed a bill. It is sent to the governor. The new government is formed. The new government is not the same government. Some other party forms the government, or some other leader becomes the chief minister. He may even advise the governor to withhold the assent, that now I would like to have a fresh mandate from the fresh electorate, from fresh assembly. Lord, the constitutional prohibition is what advice he has given you cannot go into. So in my submission, as a consequence, what is done by the governor after that advice is also, my lord, non-justiciable. Court cannot go into it. Now, please see, my lord, page 254, State of Punjab versus Sodhi Sukhdev Singh, where, my lord, 163(3) came to be considered by the Constitution bench of this court, my lord. My lord, only highlighted part, my lord, may be read. It is hardly necessary to recall that advice given by the cabinet to Raj Pramukh or the governor is expressly saved by Article 163, sub-article 3 of the Constitution, and in the case of such advice, no further question need to be considered. The same observation falls to be made in regard to the advice tendered by Public Service Commission to the Council of Ministers. My lord, then next, my lord, 107, page 255. Under Article 163(3) of the Constitution, the question whether any, and if so what, advice was tendered by ministers to the governor shall not be inquired into in any court. In view of the constitutional protection and the reason underlying such protection, I hold that in present case, the district court was right in sustaining the claim of privilege. My lord, this article itself, my lord, gives an indication that there are some communications amongst inter se constitutional functionaries which are put by the Constitution beyond the examination by the court. Constitution, my lord, Council of Ministers is also a constitutional body. Their communication with the governor, if it cannot be examined, my lord, then the governor's communication with the president also cannot be examined. And similarly, any exercise of power under Article 200 would be beyond judicial review, my lord, or rather would be just non-justiciable. I'll not use the word judicial review, non-justiciable. My lord, your lordships may, I'm just for reminding para 297, my lord, Kameshwar Singh and Valluri Chaudhary. My lord, Kameshwar Singh and Valluri Chaudhary, my lord, which I referred to. My lord, kindly come to page 255, para 297. Both have, my lord, held, both, my lord, 5 bench judgments, that exercise of power under Article 200 and as a necessary consequence 201 is legislative in nature. My lord, I have said Bihar versus Kameshwar Singh and a Valluri Chaudhary. It has been noted that the governor and the president are part of legislature and assent powers are a part of legislative process. It is in this light that the question of non-justiciability must be examined. It is submitted that once a bill is resolved and receives assent, judicial inquiry into the propriety or necessity of such a reservation is restricted.
Say commissioner, governor, not legislative. Commissioner never said that.
Government or B government, the question is, my lord, as I have put it, my lord, in page 258, my lord, there are two issues. I'm not reading it. A, the 258, my lord. I'm not reading, I'm just, my lord, paraphrasing my submission. My lord, the decisions are polycentric in nature. The very nature of the decision is such that your lordships may perhaps not have any judicially manageable standard based upon which your lordships would examine. existence or non-existence is one thing. Whether there is an assent or not is one thing. But if there is an assent would mean all options. Then, my lord, based upon what, I'm posing a question to myself, the court would examine whether this assent was rightly given or wrongly given. Second, my lord, there is a concept of constitutional committee. And the constitutional committee under our constitution is respect for one organ by the other organ. We do not have, my lord, hierarchical system that ultimately every organ's decision or conclusion would rest in one organ. There are checks and balances. For example, my lord, legislative act enactment is subject matter of your lordship's judicial review. It's not a hierarchical position, but your lordship's power of judicial review. Any decision taken by the executive, which is not a plenary constitutional power. The executive takes several decisions. My lord, the ministry, my lord, makes a policy. Ministry takes a particular decision. There are several executive functions, administrative functions. They are all subject to judicial review. But when it comes to constitutional plenary powers, more particularly of the nature which are legislative, my lord, justiciability should be denied, my lord. That is my respectful submission, my lord. My lord, on which, my lord, I am placing reliance upon one judgment, Indira Nehru Gandhi versus Raj Narayan. My lord, here your lordships have seen, my lord, a adjudication by the court by an enactment was sought to be, my lord, upturned. Please have a look at, my lord, page 258. My lord, I'm skipping through, my lord, most of the things. I'm paraphrasing it now. My lord, page 258. Para 313, my lords have.
Yes.
My lord, the Chief Justice has. Page 258, para 313.
313.
313, my lord. Indira Nehru Gandhi versus Raj Narayan. Para 577. There is ample evidence in the Constitution itself to indicate that it creates a system of checks and balances by reason of which powers are so distributed that none of three organs is set up, it sets up, can become so predominant as to disable the others from exercising and discharging powers and functions entrusted to them. Though the Constitution does not lay down the principle of separation of powers in all its rigidity, as is the case in United States Constitution, yet it envisages such a separation to a degree as was found in Ranasinghe case, so-and-so versus so-and-so. The judicial review provided expressly in our Constitution means Article 226 and 32 is one of the features upon which hinges the system of checks and balance. Neither of three constitutionally separate organs of the state can, according to the basic scheme of our Constitution today, leap outside the boundaries of its own constitutionally assigned sphere or orbit of authority into that of the other. This is the logical and natural meaning of the principle of supremacy of the Constitution. But no constitution can survive without a conscious adherence to its fine checks and balances, just as courts ought not to enter into problems entwined in the political thicket. Parliament must also respect the preserve of the courts. The principle of separation of power is a principle of restraint. My lord, it is not a prohibition. It is a principle of restraint. My lord, the very nature of the function, at the cost of repetition, my lord, I am respectfully urging, is such that it is entwined with political thicket. There may be 50 considerations weighing with the constitutional functionaries, for which your lordships may not have a judicially manageable standard to examine and decide whether it is valid or invalid. My lord, then next judgment, I'll read only the highlighted part, my lord. MP oil extraction versus state of MP. The supremacy of each of three organs of the state, legislature, executive, and judiciary in their respective fields of operation, needs to be emphasized. The power of judicial review of the executive and legislative action must be kept within the bounds of constitutional scheme so that there may not be any occasion to entertain misgivings about the role of judiciary in outstepping its limit by unwarranted judicial activism, being very often talked of in these days. So this is 1997 judgment.
Now we are in 25.
Now we are in 2025, my lord, and now again, my lord, this discussion is going on. And my lord, mostly, my lord, your lordship's intervention has been, my lord, for the benefit, but sometimes, my lord, it is believed that it is in the domain of executive. For example, my lord, one of the high court, since I have appeared, my lord, without naming, virtually the COVID management was being monitored, my lord, administered by the high court. And all our officers who were supposed to be working on the ground were sitting in my chamber and we were preparing the status reports. What is the vaccine available? What are the number of companies which manufacture remdesivir, which each company has by way of their raw material? What is the production capacity? What is the production capacity of each company? In how many days, how many remdesivir drugs will be made available, etc., etc., etc. So, my lord, that is something, my lord, which is avoidable.
That is micromanagement of the government function.
Well, your lordships have always, my lord,
That will never interfere with it. We can't ask you how a district is to be administered, how your collective could function. But suppose if particular function is entrusted to the governor, the honorable governor, and if for years together he withholds it, will that also be beyond the scope of judicial review of this court?
my lord, I would say
when this court has set aside the constitutional amendment itself, which had taken away the powers of judicial review, that no amendment should be called in question by this court. It has been found to be hitting at the basic structure of the Constitution. So, and with the judgment of, with those judgments, can we say that everything, however the highest constitutional authority may be, if it does not act, still the court would be powerless?
No, my lord. My argument, please do not misunderstand. My argument is not that the court is powerless. I am on justiciability. My lord, there is difference. There can be a power.
No, assent is given, not given. Reasons, we may not go into that as to whether the president was justified in giving the assent, as to why he has given the assent, as to why the governor has given the assent. But suppose if an act passed by a competent legislature, if the honorable governor only sits over it, that could still be the courts.
Yes, I'll answer that, my lord, in two ways. First of all, your lordships would not decide whether there is any justiciable power in your lordship or not based upon an extreme situation, my lord, which may arise. That is my first answer. And second,
like you said yesterday, the hard cases lay down a bad law.
Bad law.
And my learned brother said that hard cases lay down a good law.
Hard cases always lay down a bad law.
No.
Not at all.
No such thing.
Lord,
They will agree with me and disagree with you.
Mr. Hari Vishwa Kamath agrees with
no,
Mr.
no,
Vikramnath.
Lord, he is a very respected person, my lord, but Lord, this is
In a lighter vein.
on the lighter vein, my lord, but this is like, my lord, a candidate celebrating based only on the Ruzan coming in the morning, my lord, and distributing sweets. That's what, my lord, the other candidate would hope, that these are only Ruzan and not the real picture. So, my lord, your lordships would, my lord, in that case, my lord, even if the governor sits on the bill, the solution does not lie here. The solution lies elsewhere.
Where?
Solution lies in the political sphere. These are all political decisions. Such cases do happen, and such cases are, my lord, solved through that democratic process. Lord, it is wrong to believe that there can be circumstances where every other organ would fail, and therefore the only available organ would be this organ. Look, this organ has protected fundamental rights and your lordships are custodian of the constitution, no dispute on that. But there are certain problems which are, my lord, not solvable by the judiciary. They are to be solved, my lord, by political democratic process. When such a thing happens, my lord, we have to expect and accept that there are constitutional functionaries who are responsible and responsive because they are answerable to the people every day and at least every 5 years. In a
The
situation
Honorable
like
Governor
this,
is not answerable to anyone.
pardon me?
The Honorable Governor is not answerable.
Governor, my lord, I'll answer that. I'll answer that immediately. The governor is the most vulnerable office. He can be removed without anything else. My lord, the moment the chief minister goes to the prime minister or the president and look at the facts of this case, this is what has happened and such things do happen. That when governor sits over it, my lord, for good reasons, bad reasons, no reason, whatever, then political process takes over. And governor can be called back. Governor can be, some other person can go as a governor. Why not, my lord? And why can we not trust other constitutional functionaries? It's a matter of, my lord, the chief minister talking to the other constitutional functionaries that we are facing a constitutional problem. My lord, whenever something happens, my lord, in the judiciary, I'm not giving, my lord, a comparative example. My lord, the system takes care of it. There is an inbuilt system, my lord. Every problem does not come here on the judicial side. Your lordship takes a decision on the administrative side.